Hi, everyone. I'm Susan Saravo with Comerica's marketing team. Thank you for joining this LinkedIn Live. This is Business Transition Planning, Keeping It in the Family. And today I'm joined by my colleagues, Bob Buchanan and James Nestor. Welcome, gentlemen.
Thank you, Susan. Great to be here.
Great to have you here.
It's a really interesting time to be working in this field, simply because if you just look at the demographics, we have the baby boomer generation who are now, moving into a stage of life where a lot of them started businesses, and a lot of the baby boomer generation are now getting to retirement age. And so they have businesses that they, started 20, 30 years ago, and they're now looking at how do I integrate those into my overall plan? How do I, move beyond being a business owner and be able to use that asset to accomplish my overall financial goals? So even just based on kind of demographics, we're at a time where you have a lot of business owners who are looking at these issues.
Right. And you want to help them make the best decision for them and their family as well. Okay, well, Bob is working on his technology. You never know, and we're going to have a few technology issues. So, James, we're going to go ahead and move forward. So just a quick overview on this presentation today. We're going to go through the right preparations, the right guidance, the right strategies, and the right technique. Okay, so let's go ahead with the right preparations. How to prepare and avoid pitfalls. James, tell us a little bit about that.
Yeah, absolutely. So I think the key thing here is to do planning and to make sure that you have something in place, that you know what you want to accomplish and you know how you're going to get there before something happens, right? So one of the things that can really derail a plan is if something unexpected happens. A business owner has an event where, for instance, they may become disabled. They may have a situation where they're not able to work in the business anymore. They may have a situation where they feel like they need to, exit the business sooner than they thought. And so it's important to make sure that the planning has been done on the front end to make sure that we're still going to accomplish all of those goals. The more planning that you have in place at the beginning, the more there's governance framework set up, the more you have a system in place so that if something happens to the business owner, we know the business and the family of the business owner are going to be protected, the better things are going to be for everybody.
Okay. And I can see that Bob has joined us again. Bob, glad to see that you're back.
Yeah, I'm not sure what happened there. Internet connection issues, I think.
All right. Well, let's go ahead and just move on to getting started with your business transition to a family member. What do you want to do? I know you're going to tell us about what do people want to do after they make that transition. That's a really important question, right?
It is. And the questions here are really just to get people thinking about what's next. And part of it ties into that last section. So when you're beginning this process, it's really important to ask yourself, what will I do? What am I going to do the next day? Especially when you're transferring it to family members, there's a tendency for owners to want to stay involved. And sometimes that can create some family stress that is unnecessary unless that's laid out very clearly early on. The next question you really want to ask is what do I need? And can the business provide what I need? And so that really is much more of a financial question, although what do I need emotionally sometimes is tied in with the business as well. And so when you're asking what I need, it's really important to understand financially what are those things that I'm going to spend money on the rest of my life? And do I have enough money to spend? And if you don't, then the next question is, can my business provide that? And then how can it provide that? Will it provide that through ongoing cash flow from the business, or am I going to sell the business to my children? And if the answer is, am I going to sell it, transfer it for value, then you really start to have to think about the risk that you take in doing that. And that risk isn't always financial. A lot of it is. You're typically not going to sell your business to your children for cash. Generally speaking, they don't have the money to buy your company. And so it's going to be done over time with a note. And do you want to take the risk of that note, having your children pay you back with the cash flow of a business that you're no longer running? So the questions start to pop up. Can they run the business? Can they run it sufficiently well to support themselves, support the employees, and pay me what I need to get from the business? And so that risk question, all of these tie in together so closely, but that risk question is a question that I think a lot of people don't really fully comprehend. And when they start asking and thinking about the risk they're going to be taking going forward, those financial risks rise to the top. But there are other risks as well, right? Do I have the risk of alienating some of my children because only some are going to work in the business? Is there a risk that my family is going to have these stresses going forward because I haven't adequately set up governance, or I haven't adequately set up an economic plan that's viable? So those questions are sort of central and key to ask early on, and they really drive from those questions in the last page, right? Of what is it that you want, what do you need, and how do you get moving on it?
Well, those are oftentimes some emotional kinds of questions and issues that business owners grapple with. So good that you mentioned all those. Let's talk about determining factors, Bob.
Yeah. So Susan, there are determining factors in how you move forward. And early on, again, it's really important to start thinking about whether you're transferring ownership or whether you're transferring management or whether you're transferring both. Because you can transfer management without transferring ownership, continue to be an owner and become less and less involved. Sometimes that means being on a board while your children run the business, or whoever you're transferring to in the family. Or you could do it over time, right? So the question is, to whom, when, what, and how? What are you transferring? To whom are you transferring it? Is there a timeline over which you're going to transfer it? Is it 10% this year and 10% next year, so that you stay in control for some period of time and mitigate that risk of operations and making sure you get paid? How do you transfer it? Is it going to be by gifting? And I know James is going to talk about some of that later. Is it going to be by a sale? Is it going to be some combination of gift and sale? And what are you transferring? So we talked about ownership versus management, but ownership can take different forms. There are voting shares or non-voting shares. There are preferred shares and common shares. So the question of how you do this really brings up a lot more questions. The problem, not the problem, but the issue with any sort of business transition is that there are a million things to think about, and we can't talk about all of them, right? And the other thing is, you can't solve every problem. When you go into these kinds of transitions, especially with family, there are going to be issues that come up that you just can't solve. And that's okay. You don't have to solve everything. The idea is to get to the best place you can and create processes and governance that make it easier, and create a plan and execute on that plan over the time frame that you want to execute.
Okay. And I know you talk a lot about getting started early. I've heard you say it's never too
Absolutely.
early to get started on this kind of stuff. There's so many questions
it's
that need
never
to be answered.
That's absolutely key, Susan.
Okay.
And especially with intra-family transfers, the sooner you start those conversations with the next generation of owners, the more issues you can surface and address. But if you wait until you're ready to retire, and suddenly you're putting ownership in the hands of a next generation, some of whom may or may not want it, some of whom may not be prepared, that's when you come up with these issues or these problems that are much more difficult to solve. If you start early and you get help, there are a lot of professionals out there that can help walk through these issues. If you start early and get help, you can uncover the things that are going to cause the crash later down the road.
Okay, we want to avoid crashes at all costs. So
you always want to avoid a crash.
All right, James.
Yeah.
So we talked about preparations with Bob. Now let's talk about the right guidance with you. What do you want to tell us about guidance?
Sure. Well, first of all, what I always think is really important, especially about those points Bob was bringing up about seeing what you want to get out of this whole thing. What are the goals that we're trying to accomplish? What do you need to get out of your business? That's, great set of questions to be asking. And that frequently is where Bob and I actually get to work together on clients as well. So that's frequently where the connection comes in between Bob and myself. Frequently a client will come to Bob and they'll say, well, I'm looking at potentially doing some business transition planning. And sometimes Bob will say, well, let's talk to a strategist like James first and figure out what you need on the personal side so that informs the whole decision. And so what I'm going to talk about today are some of the techniques that we use to help address those personal goals and some of the specific techniques in particular about tax liability and doing tax management with these kind of deals. So the first thing that we're going to talk about is gift and transfer taxes. Okay, and the reason why I wanted to bring that up as the first thing to cover is it's important to understand that this is the framework that is going to control basically these intra-family transfers. When you have a deal where someone is going to be, either selling or gifting a business to family members, it's different than when you have a situation where you have a third-party buyer, you have one of these private equity deals, simply because the IRS is not just going to let you sell your business to a family member for whatever you want. And there are limits on how much you can gift, right? So the IRS is not going to just say, oh, you want to give your business to your kids? Well, you can just give it to them tax-free. That's not how it works. So gift and transfer taxes are the framework. And it's important to understand that you have a limited amount of money that you are allowed to either give away during your life, which is covered by gift tax exemptions, or that you're allowed to leave as part of your estate. That exemption amount is tied together. So it's the same amount. And so currently in 2022, any person has $12.06 million available that they can either give away while they're alive or they can leave as part of their estate. Beyond that amount, there's 40% tax. And so it's worth noting that the gift tax amount or the estate tax amount, same amount there, it's 40%, is higher than the highest marginal income tax rate. Okay, so this is a very onerous tax. It's one that we really want to make sure that we plan for. Now, the thing that will come to mind to many business owners is a lot of businesses are going to be worth more than that exemption amount. Okay, so just right off the bat, we're going to have to do something in order to make sure that we can get this business transitioned without paying 40% tax and all that. We need to make sure that we are using that exemption in a very efficient manner as well. We need to make sure that we are planning so that we can get the best value out of that. We're leveraging that exemption and not just throwing it away. We don't want to give away a $100 million business and say, well, we're going to exempt the first 12.06 million and we're just pay 40% tax on the whole rest of the $100 million business. That's not a good use of that exemption, and that's not a good way to do tax planning. So on the gift and transfer taxes that we'll look at next, it's just important to realize that your gifts during life tie in to your overall estate plan. And so it's always a balancing act. You do something during life, you use part of your exemption during life, you are trading that for part of your exemption you'd be able to use as part of your estate. And so it's very, very important that we make sure that you are not overly taxing your exemption, that you are not putting undue strain on it, and that you're using the best kind of assets possible as part of the exemption. And a lot of the time for a business, there are more efficient ways to move it to the next generation than simply gifting it because of these taxes. So I want to just cover, those overall taxes and the overall tax framework so that we kind of understand what we're talking about. The techniques we'll get into after this are all going to be ways that we can plan efficiently around these gift and estate taxes.
Okay, James, so we're going to move on to the right strategies, and you're going to talk about strategies that freeze the value of a business for estate and gift tax purposes. That can be particularly effective. So tell us why that is. Absolutely.
So this is going to be one of the really key concepts to take away from our discussion today. So basically, we're going to talk about a lot of different tax topics. I know tax is not everyone's favorite subject, but if there's one takeaway, it's this value freeze concept. This is the idea that particularly if you have a business that is going to undergo a lot of growth. So we have a business that maybe today it's worth 10 million. And you think that, our EBITDA is growing, our sales are growing. And we think that 10 years from now, this business now that's worth $10 million, maybe it'll worth $50 million. Maybe it'll be worth $100 million. We need to do something now to make sure that that appreciation is not going to make our gift and estate tax problem worse. And so value freeze techniques are going to be techniques that serve to remove an asset from our estate. So move it somewhere else, which can be family members, can be to a trust. Take that asset and move it out of the estate and take back instead into the estate a promissory note. So essentially what we're going to be doing is we're going to be removing an asset from the estate for value. So remember, it's not counting against our gift tax exemption because it's being paid for. But that note that we're going to take back, that promissory note, is not going to increase in value at the same rate the business is. So that value freeze where we're trading an asset for a note. So the asset's going to be doing its very, very intense appreciation outside of our estate, whereas the note is going to be not experiencing that same appreciation, which is what's inside the estate. That is the key concept that's going to inform everything else that we talk about here today.
Okay, well, it's so much to consider and why advanced planning is so necessary for all of this. Okay, let's move on to talking about an installment sale to a family member.
Absolutely. So the installment sale to a family member, I think, is a good way to start this discussion because it's the most basic example of one of these value freeze techniques that we're talking about. So it's pretty straightforward. I mean, this is what it sounds like. This is basically taking, your family business and selling it to family members. Now, because as we talked about, these are not third-party buyers. This is not an arm's length transaction of the normal type we think about with a third-party buyer. There are various IRS rules that are going to govern how this has to happen. So it sounds simple, just selling a business to family members for taking a note back, but there are complications. So basically one of the main ones is interest rate. Okay. So the IRS is going to set a minimum rate of interest. You have to charge a minimum rate of interest on that intra-family loan note. Okay. Can't be an interest-free loan because the IRS is going to charge income tax on interest. And so that's why they want there to be that minimum rate of interest. Now, that IRS rate of interest is called the applicable federal rate, or the AFR. It's something the IRS publishes every month. You can look it up. If you go in Google and you say, what's this month's AFR, it'll come right up. It's currently very, very favorable. Okay, so because it's tied to 10-year treasuries, it is currently very low. And so that's good because it means you can do one of these deals. You could sell your business to a family member for a note that is charging something like, 2% interest or under. And, you could make it an interest-only loan. And so that's very favorable. Now, when interest rates go up, these kind of deals become harder because that minimum IRS rate of interest may make it so it's a more onerous type of transaction. But in a situation like today, where we have fairly low interest rates, although they may be on their way up, we have some real opportunities to do one of those sales to family members. Now, the other big issue that's going to come up is valuation. So when you have a sale between related parties, the IRS is not going to just allow the parties to have what's called the benefit of the bargain. Okay, so that means the IRS is not going to say, oh, well, my son and I were talking about the family business and we decided I'm going to sell the family business to my son for $100. And we figured that'd be a good deal. Now, that's not going to work for the IRS. Okay, the IRS is going to have real issues with that. They're going to say, no, you need to find another valuation. You need what they call a qualified valuation, which is where you have a professional valuation person come in. Now, this is actually interesting. It sounds like a burden, but is actually an opportunity. And so this can really inform what kind of shares you want to do this deal with. It can inform how you want to structure the deal as well. So valuation is key. I actually want to get Bob's take on this a little bit as well, because Bob actually has a background as a valuation professional. So this is actually a field that Bob has worked in quite a bit. And so Bob, could you tell us about some of the strategies and opportunities around valuation with one of these deals?
Sure, but before I do that, I want to talk about the note for just a moment. So these notes, one of the interesting things about the notes is while the asset is appreciating outside the estate, the note is actually declining in value as it gets paid down. And even if it's an interest-only note and you're not paying down principal, the note is subordinated to other debt. So the bank that is the financier of the company isn't going to allow a note to take precedence over their debt. And so subordinated debt typically carries an interest rate that's higher than senior bank debt. But if you're using the AFR, that interest rate's actually lower than senior bank debt. So you're not getting the rate of return that's appropriate for the instrument, for that note. And so that note itself is worth less than the face value of the note. If you were to go sell that in the marketplace to a third-party buyer, the third-party buyer looks at that note and says, hey, this is great. It's $10 million. I'm getting 2% on it, but I should be getting 10%. And because they should be getting a higher interest rate, they value the note lower. And so in the estate, in the seller's estate, in the hands of the seller, that note is worth less. And so not only did they transfer a business at a freeze value of, let's say, $10 million, but the note is worth less than 10 and the business is growing. And so the win on the tax side is just all the way around. It's a phenomenal opportunity. The valuation aspect of transferring intra-family, is, like James said, you've got to have a qualified appraisal, but you can set up these transfers in ways that you're transferring less than control. And so transfers can be done over a period of time. You could sell 45% to your children one year and 45% the next year in a different tax year. And both of those transfers are non-control interests. And because they're non-control interests, they don't have the same pro rata value as the company does. So a $10 million company, you sell 45%, you would think it's worth $4.5 million. Only under the IRS rules, you can take what are called discounts for lack of control and lack of marketability. And those discounts might lower that value to, let's say, 30% less than that, $3 million instead of 4.5. So now you've moved $4.5 million in real value to your next generation for $3 million in taxable value. So it's just a great win. That's great for gifting. For transfers for value, it really depends on what you want to get out of it. As the seller, you may need the cash flow from a higher value sale, but you may not. You may want to make a quote gift. It's not really a gift because you're selling for value, but you might want to sell it to your children for a lower value. And through valuation, you can do that. And it's something that I think a lot of people may have heard, that valuation quote discounts are going away for intra-family transfers. That's not the case for operating companies. That's for holding entities, things that hold real estate or securities. But for operating companies, those discounts are still going to exist. And it's a great way to transfer more value for less dollars without having the IRS come back and hit you with a penalty or a tax.
Absolutely. And Bob, as I think, one of the really great points you touched on there also was the valuation and the amount that we're going to set the note and the terms of the note and how it's being paid really is very, very useful way of tying all this back into the personal financial plan of the business owner as well, because you can really dial that in to meet their cash flow needs. It's a great opportunity to take, for most business owners, their business is going to be their most valuable asset. And it's a great way that you can take what is an incredibly valuable asset but is not liquid. And as part of the overall financial plan, doing one of these transactions, it's a great way that you can have that convert into an annuitized income stream, which can be really, really helpful for the business owner's overall planning as well. So as Bob was saying, these kind of transactions, you get wins on multiple fronts with these. It's kind of, there's many different opportunities, many different bites of the apple. So they're great, great technique.
Okay. Well, lots of great discussion here. So we covered the right preparations, the right guidance, the right strategies. Now we're going to move on to the right techniques. So James, this is your area here where you say correct choice of techniques can maximize tax efficiency while also achieving the family's other important goals. So tell us more about that.
Absolutely. So this is the part where what we're going to take is that knowledge we were just building on. So we talked about the concept of an asset freeze in the estate, and we talked about the very basic way to do it, with basically having the asset be traded for a note that comes back to the estate. These are techniques that can all turn that up a notch, right? So these are things that take that to the next level, are really going to enhance both the tax planning effects of the structure and also allow other considerations. So things like control of the business to come into play. So the first one that we're going to talk about is a technique called a self-canceling installment note. The self-canceling installment note, attorneys love, little abbreviations for things. So they call this a SCIN, SCIN. And so the self-canceling installment note is a note that, like a normal promissory note, but has one very special term to it, which is that if the person who loaned the money on the note, if they pass away before the note is paid out, the note is canceled. Now, this obviously makes this a much more interesting estate planning technique because, of course, in a normal asset freeze, we're just selling the asset, we're taking a note back, and yeah, that note's valuation is frozen, or as Bob is pointing out, is actually even going down because of particular aspects of the note for valuation purposes. But we still have that note and that value, coming back into the estate. So while we've saved some tax, there is a limit. We have, that value of that note kind of, boomeranging back into our estate. So the SCIN is an opportunity to say, hey, what if that didn't have to happen? What if we could have, payments of the note happen for a while, but then if the business owner passes away before the note term, comes due, then maybe that note is just extinguished, so that value wouldn't come back into the estate. So obviously that sounds like that would be a really favorable way to do things for estate tax planning. Now, the important thing to realize is, obviously something that sounds like that good a deal, obviously the IRS is aware of this, and the IRS is going to have very particular types of, rules and regulations they apply to these things. So, some of the things I say, these are the caveats I'm talking about, things to be aware of. Okay. The IRS is going to insist that you treat this transaction like it was an arm's length transaction. And, if I were selling a business, let's say I'm selling my business to Bob, and I'm not related to Bob, would I realistically do that for the same price I would do to anyone else and say, oh, by the way, Bob, if I pass away before the deal is done, we'll just call it even. You don't have to pay the note back. No, that wouldn't happen. And so the IRS says, well, you can't do that on this note and family member either. So they're going to want you to have actually gone in and shown a couple of things. You need to show that this term, the self-cancellation term, if the lender passes away, was something that was bargained for as part of the consideration, right? So you have to basically have, the negotiations on both sides showing that this is a term we specifically wanted in the deal and we paid for it. And how you pay for it is what's called a risk premium. So what has to be done is you have to go in, you have to make sure that there has been some calculations done, some actuarial calculations on the life expectancy of the lender, and that there was a risk premium added to the note. So in other words, you're going to be paying more on this note than you would be on the note if you didn't have that self-cancellation provision. So you're basically saying, I'm going to pay you more for my, wager that maybe you're not going to survive, the term of this note. So that has to all be done. That's obviously going to be a lot more complicated than just normal promissory note, right? You have to go in there and you have to make sure that all of these calculations are done. You have to make sure that, all the actuarial data has been taken into effect, all of that. You also got to make sure there's some restrictions on the ability of the person who's selling the business on one of these notes to still have the control. Bob was talking about some people want to have that control factor. That becomes much more difficult in one of these kind of deals. The IRS is really going to want to see that this asset left your hands and that you're not still involved with it. So it makes it a lot more complicated on that front as well. Also, Bob and I were actually talking earlier, and I'll let Bob chat about this a little bit. It creates an issue for, let's say, the surviving spouse of the person who sold the business. What happens if they pass away? And remember, we were betting on that income stream. So Bob, did you want to chime in on that?
Thanks, Dave. So really two things there. One, so even with the risk premium added to the note, remember that you're adding that risk premium to the applicable federal rate, which is an extraordinarily low rate. So even with the premium added to the note, you tend to be below the market rate of interest for a similar note. And so you still could maybe discount that note in an estate, except the note disappears. So there is no estate to discount it in, but you could transfer it to someone at a discount from face value. The issue around someone dying and the note not being repaid, when we go back to what we first started talking about, what do you need? Always start with what you need. And if what you need is cash flow over a long period of time, and that's guaranteed cash flow or as guaranteed as it can be coming from the operation of a business, and your spouse needs that after you die, you ought not to get into a SCIN, right? A self-canceling installment note, which disappears at your death, leaves your spouse with no additional income.
And one of the techniques also sometimes that you can do with this as well is there are techniques that you can use some life insurance planning as well. To work with the SCIN also. So that's, another way. And, it's a lot of times clients, so I have these discussions with clients that say, oh, James, you're drawing another line here, another thing on the board. But it can be very, very helpful to add in another component to this as well. Maybe some of that income that's coming back from the SCIN, maybe we use that to go towards a life insurance policy and a life insurance trust. And then, if we have the death of the lender on the promissory note and that note gets wiped out, well, at least we have a life insurance policy on that person's life that can be there to provide for the spouse as well. So there's, all sorts of different ways that you can make this work. As Bob said, certainly not an appropriate technique for everybody, but there's ways that you can integrate this into your planning. And these kind of discussions are why it's so important to look at this stuff early and to have this plan in effect, and have this planning be done really, really on the front end so that we can have all these discussions and we can find the most appropriate tool for the job.
That makes a lot of sense, James. Okay, so for those of you who joined us late, this is business transition planning, keeping it in the family for any business owners who are planning to transition to family members. All right, we have one more area for you to cover, James. Another acronym here, IDGT. Tell us what that is and how that benefits people.
Yeah, absolutely. Attorneys love acronyms, so this one, the IDGT, a lot of attorneys call it IDGT. And so this is an intentionally defective grantor trust. And this kind of deal, the sale to an intentionally defective grantor trust, I'd say overall is often one of the most successful techniques for many clients. Again, nothing is, appropriate for 100% of all clients, and these need to be carefully discussed with your attorney and CPA. But this one is something that really, really works for a lot of people. I've done a lot of these for my clients over the years. And they're one of the things that clients come back and you get feedback 5 years down the road from clients about doing, a particular kind of technique. Sometimes they're like, oh, why did we do that? The IDGT comes back and people always say, that was a good thing. That was good that we did that. This is a good technique. So this, again, is an opportunity to further leverage these concepts we've been talking about. So the concept of the estate freeze, the concept of the intrafamily sale. This is an opportunity to really turn that up to the next level. So an IDGT is a particular kind of trust. When we say it's an intentionally defective trust, what we mean is this is a trust that is effective for moving an asset out of your estate. So once an asset is owned by this kind of trust, rather than you, it's not part of your estate anymore. You've successfully gifted it, or you've successfully sold it or removed it from your estate. But the defective part is income taxes. Okay, so this is a trust that actually takes advantage of a curious little arbitrage provision between what the IRS considers to be the income tax treatment of a trust and what they consider the gift and estate tax treatment to a trust. Why it's intentionally defective is that you set this trust up as the grantor. You either gift an asset to it or sell an asset to it, and those assets are removed from your estate for estate and gift tax purposes, but you're still paying the income tax on them. Now, this is a really, really powerful technique. And when you think about it, what you're doing is you're giving the opportunity for the asset you've put in this trust to be growing tax-free because you're picking up the tax with the assets from your estate. So every time you're paying the taxes on this trust, you're basically giving another free gift to the trust. You're also depleting assets that are within your estate, which is where they'd be subject to that 40% tax if we're over the estate tax exemption amount. And we're shifting that value to the trust. And so this is a way that you can hugely increase the value going to one of these trusts. Now, there's another really interesting factor that comes up with these intentionally defective grantor trusts, which is because it is considered to be basically a disregarded transaction for income tax purposes, normally when we sell an asset, we would expect that we would have some capital gains income we'd have to realize from that. Not if you sell it to one of these trusts. Because the trust is not a separate entity from you for income tax purposes. These deals are actually disregarded for purposes of capital gains tax in the deal. So there's actually no tax to you when you would sell an asset to one of these trusts. So you add all these together and you realize why this is such a popular technique. We have kind of leverage upon leverage upon leverage in these deals. So, the sale to an IDGT is really, really an opportunity that you can basically have a tax-free, removal of this asset from your estate, particularly a business. It's an opportunity, and remember, we can take a valuation discount on that still. So Bob's valuation discount still apply to that. It's going to be a tax-free transaction, so a sale. But even though it's a tax-free transaction, we're not using our gift tax exemption because it's a sale. Okay. Now, in practice, and we'll show, on the next slide, we're going to look at how the mechanics of this actually work. We actually will use part of your gift exemption. We'll make a seed gift to one of these trusts. And the reason we have to do that is the same concept we were talking about with the SCIN. So the IRS is always going to look at these deals and say, would you have done that with a third-party arm's length buyer? And so if you have a trust and the trust has no value in it at the beginning, would you really be willing to sell an asset to that trust, right? You got to make it credit worthy, basically. And so you got to seed some assets there. Typically, people will do a gift that's going to be 10% of the post-sale value of the transaction. They'll seed that as a gift to the trust, but again, using a lot less than their whole estate tax or gift tax exemption amount. And then the rest of the business or the rest of the asset is going to go through on one of these sales. So this slide that we have up here basically shows you the mechanics of how this works. So as you see, we have a client initially gifting that 10% seed gift into the IDGT or the IDGT. That makes it, a credit-worthy borrower, basically. And then the business owner is going to sell shares of their business to the IDGT. They're going to take a promissory note back in return. That sale would not be a taxable transaction under current rules. We'll talk about that in a sec. And, that IDGT is then going to be paying, interest annually to the client, on typically an interest-only note. It's going to be at the AFR. And basically, it's the same as that, intra-family sale we were looking at before. But now, any of that income that's going to be happening in the IDGT is going to be taxed to the business owner, not to the trust itself. So you have the opportunity to grow tax-free. And so this is a really, really powerful tool for moving a large amount of value, a large amount of valuable assets, particularly something like a business, out of someone's estate, moving it into a trust, preserving a significant amount of their estate and gift tax exemption, and also just doing it in a really tax-efficient manner. And so as you can see, there's so many different bites at the apple where you can save on this kind of transaction. That's why they're such a popular technique. That's why they're such a powerful technique. Now, the one caveat I raised as well, Bob was mentioning the valuation discounts being on the radar as something people want to get rid of. This is too, okay? So the bill that came out in September from the House Ways and Means Committee would have actually changed the treatment of these intentionally defective grantor trusts. It would have said you can't do that whole thing anymore where basically you're transferring something out of your estate, but you still pay the income tax. Basically, the law change would have said, if you pay the income taxes for something, it's part of your estate. And it also would have made that deal where you're selling, a business and taking the note back, it would have made that taxable. So it would have made that so that would be a capital gains realization event. Now, important to note, that did not pass. Okay, so these are still part of the law. I would say it's just worth noting. Yes, the IRS knows this is a very powerful technique. It's something that's floating around out there that the laws may change on it at some point. But yeah, this is still good law at the moment. So we'll have to see what happens. But at the moment, this is going to be one of the most powerful techniques. Again, it's a way of taking the things we've talked about before. The asset freeze technique, the sale to a family member, the valuation discounts. This takes all those and rolls together in this structure that adds additional tax benefit and just really makes the whole thing a real powerhouse for estate planning. So really one of my favorite techniques. And as I said, clients typically who've done this, typically it's one that gets rave reviews. So certainly not appropriate for everybody, as well. There are different sorts of factors that can come up. And you always want to make sure you discuss this with, really experienced attorneys and accountants who do this kind of stuff all the time. But certainly something to have on your radar screen to have that discussion with your professionals, with your team, and to know that this is a really powerful technique that's out there.
So James, you said, I love you said that they come back 5 years later and say thank you. I tell people all the time, business owners in particular don't measure success at a point in time. They measure success over very long periods of time. And often they'll go through a transfer and come back 5 or 10 years later and say, I didn't do that right? I missed something. I could have done that better. And when they come back 5 years later and say, hey, this really worked, that was perfect, then you've gotten it right.
Absolutely, for sure. So yeah, that's as I said, I tried to keep we know the tax is something that's not necessarily the most exciting topic, but I think that learning about value freezes today and learning about some of these techniques and how they can really amplify that, I just think that'll be something that I hope sticks with people today and helps create a lot of discussions with your planning team.
Well, for both of you, it seems like you can't emphasize enough for business owners to really understand the tax implications about every single decision they make along the way.
Yeah, absolutely.
And I think, not just tax, right? This is about their personal planning implications, their cash flow implications, and their emotional implications. Every time they make an emotional decision, there's going to be an economic impact. And every time they make an economic decision, there's an emotional impact. And this is really about balancing all that out and getting to a place where you've reached the most efficient transfer that you can in a way that meets all of your family and emotional needs.
Okay, great points. All right, we do have a question here from our audience. I want to say thanks to everybody who is watching us live. We do have a question in the comments. Any other questions, go ahead and type them in. I'll be monitoring those. Question from Chris. Bob, I think you touched on this, but you might want to talk a little bit more. Bob, why would an owner ever transfer their interest for less than full value?
Yeah, so that's a great question. And you see this all the time with people saying, look, my company's worth $50 million. I want $50 million for it. Well, if they're transferring internally to a family member, maybe they don't really need $50 million. Maybe what they really need is $1 million a year in cash flow until they die. And they can get that and transfer their business for less than the 50 million or whatever that number is, by setting up an installment note like we were talking about. So really, when you're doing this, a business owner has to think about, do I want value or do I want something else? And something else is typically cash flow. Sometimes that something else is to set up my children, or is to make sure that the business is sustainable for a long period of time because I have a community legacy to protect or employees to protect. So people will give up value for all kinds of reasons. And the general reasons are more emotional than economic. So again, if you only need the value of 20 million over the rest of your life, and you can take care of a group of people that are meaningful to you by doing that, then maybe you would transfer it for less than the 50. You have to be careful about transferring it for less than fair market value, because the difference could be seen as a gift by the IRS and could be taxable. So it's important to think about how you do it. We talked about maybe transferring a little bit at a time and taking discounts, how you structure the notes and things like that. But there are lots of reasons people might transfer for less than full value.
Okay, thanks, Bob. So James, quick question for you here. How can a business owner decide when it might be the right time to implement some of these techniques that we have discussed today?
Absolutely. Well, that's a great question. I think it dials in directly to one of our main themes today, which is, first of all, anytime's a good time to be having these discussions. So if you're a business owner, this is a great time to talk to your planning team, talk to your attorney, talk to your CPA, because no time is too early to be planning for these. Now, in particular, for the techniques we were talking about, such as the asset freeze techniques, the key thing is going to be to realize when your business might be on a really strong upswing, right? Because that's going to be the appropriate time to freeze. If you have a business that currently is worth $10 million and you just really have seen your sales go through the roof, you really think your business is going to be worth a lot more money, in the near future, that's going to be the time when you get the most value out of that asset freeze, right? The freeze technique is not something when, your business is now at maximum value and we're getting ready to sell it. That's not the time to freeze it because that's not going to help anything. So when you realize that you're on that upswing, when you can kind of feel that upswing, that's going to be the opportunity to do one of these asset freezes. But again, never too early to do this planning. All right. It's always a good time to get in front of your team, talking with your attorney, your CPA, your wealth planning team about these kind of issues. Very, very important to, make that part of your discussion you're having on a daily basis with your team members.
Okay. And to both of you, can these techniques help with family dynamics or disputes involving family members?
Yeah, absolutely. Go ahead, Bob. Let's start.
No, you go and start, and I'll wrap up.
Okay. Yeah. Now I was going to say that's really, really something that is one of my favorite parts of doing this kind of planning is it can really, really help families stay together. A lot of the time you'll see a family business can be a very divisive thing, particularly, as Bob mentioned earlier, when you have a situation where some family members work in the business, but it's the main asset the parents have. So they're looking at a situation where they might have to leave the business, to siblings, who don't work in the business, and you're going to have a sibling who does work in the business who may have those feelings of resentment. Really, really big opportunities to avoid a lot of that with this kind of planning. I think particularly the more structure you have in place, the less disputes you're going to have. And that's really what I always emphasize to clients is you want to have everyone in a structure. You want to fit them into this structure that makes sure everything's going to happen the right way and kind of keeps everyone on the path. Because if people are following the structure that was set up by mom and dad, that's going to be the surest way to make sure that they don't end up at each other's throats. You want to make sure that that's as structured as possible.
And early on in the first couple of slides, there were some comments about governance, and the governance issues are, I think, what James is getting at. Typically, business owners, when they're a sole owner, or maybe it's a husband and wife owner, they don't have a real shareholders agreement. They don't have a board of directors. They don't have the kind of governance that's going to be needed in the next generation, or the generation after that, or the generation after that. And so starting early and getting everybody on board with these governance structures, who's going to do what, who has what power, who has what responsibility, what do people get paid, how is that determined, how is it going to transfer to the next generation, what can I do with my shares? All of those things need to be addressed early on and before the transfers are made. Because if you get them signed on as they receive shares, then they're caught in that and they'll buy into it. But if you wait until afterward, then you've got to get their permission. And sometimes that's pretty hard to do, right? It's especially if siblings have a rivalry going, like you said, one's inside and one's outside. And the one inside wants to pay themselves, millions of dollars in salary, and that reduces the distributions available to those outside. There needs to be a structure around that. And beyond the governance structure for the business, oftentimes what we see in the family dynamics world is a structure for the family, a family council, some sort of family governance structures as well, so that you can take disputes from the business and the family and bring them together because they're all tied together.
All right. Well, lots of great advice. We covered a whole lot of ground today. How about final thoughts from both of you? James, final piece of advice from you.
I think, the piece of advice I would give folks is, first of all, to start looking at these questions early. And also just to make sure that you're remembering that the business transition side really ties in with your personal planning as well. That, I think, is one of the real takeaways from here, is to make sure that the personal planning and the business transition planning are all lined up and all synced up. That's, one of the parts of my job I think is really, really rewarding and a real value add to clients is when Bob and I get to work together on clients, because we're coming at it from both sides, from the business side, from the personal side, and we can make sure everything works together as a cohesive whole. And that's really, really important, because when you're talking about a client achieving their goals, they need to be covering all their bases like that. So I think that's one of the real important takeaways, I think, from this discussion.
Yeah, you're looking at their whole life. So that's really important. Bob, how about you? Final piece of advice?
Yeah, I think starting early is the most important thing, but you start early so that you can understand the implications of what you're doing. And that's the whole reason for starting early, is to make sure that as you move down the path toward whatever your transition is, you understand the economic cost of emotional decision making, the qualitative and quantitative, how they work together, and what you're giving up for what you're getting. And that's really the key to having a successful transition. If you know ahead of time that you're giving up value for a particular emotional issue, that's okay. But if you don't know, then that's not okay. And starting early and bringing in professionals to help go through that process and help you understand what it means to take care of your employees, what that costs on an economic basis, might change your mind about how much you want to take care of your employees.
Okay, well, thanks so much to the both of you. And thanks to those of you who are watching us live today. Really appreciate you spending some time with us. So Bob and James have both written articles that address these issues that we talked about today. And we'll put the links in the comments section of this. So if any of you see the replay and you want to take a look at those articles, keep them for notes, then you can find them in the comments section. So again, thank you so much. Have a great evening and rest of the day, everyone. Take care.
Thanks, Susan.
Thank you.